The JMF Advisors Show is a podcast for business owners, C-suite executives, and entrepreneurs who are looking to build, grow, or even exit a business.
We bring in some of our best financial advisors to interview experts on business best practices, hot topics, and sprinkle in some tax and accounting help.
If you're a business owner, startup founder, CFO, or just starting your side hustle, this podcast is for you.
All right, guys, welcome back to the JMF Advisor Show. My name is Thornton Jamison with JMF, and I have here David Hughes of Hardin and Hughes. Thanks for coming.
Yeah,
I really appreciate it. Really appreciate it. So you specialize in labor law.
I do. So I am a partner at Hardin and Hughes here in Tuscaloosa, and along with my partner Chuck Hardin, we do a variety of legal services, but I primarily specialize in labor and employment law.
Okay, great. And we get questions all the time about, I'll get clients calling asking labor law questions, and I'm real quick to say you need to reach out to an attorney. I'm not an attorney. This stuff can get pretty in depth, so we appreciate you coming on. The first topic we wanted to get into was the new Alabama overtime laws, the overtime exemption.
Right. So first of all, I'll say I appreciate that, and we do the same thing. Yeah. If anybody calls me with any type of tax or accounting question, I immediately say, call an accountant, call JMF.
Right.
So they're actually, interestingly enough, there is not per se an Alabama overtime law. So employers in Alabama are required to comply with the overtime laws, but the overtime law that they do have to comply with is a federal law.
Okay.
So there is a federal overtime law, which includes minimum wage, called the Fair Labor Standards Act, which is known as the FLSA. But it being a federal law, it applies to the entire country, so every state. Now, some states, such as California and New York and other states, have specific state laws that supplement this federal overtime law.
Okay.
But Alabama does not have that. So if you are an employer or an employee in Alabama, the only overtime or minimum wage law that you need to be concerned with or comply with is the federal law, the FLSA. Now, one caveat to that is that, say that you are an Alabama employer, but you have employees who are based in other states. So if you've got you are an employer and you've got a sales rep in California, then you would need to comply both with the federal law, which covers everybody, including Alabama, but also the California state law.
Okay.
But for an employer who has employees in Alabama, it's the federal law that applies. Now, you had alluded to there has been a recent change to a portion of the overtime laws that is important for everyone, including Alabama employers.
Okay.
So the overtime law, not surprisingly, is a little complicated with many details. It's not quite as complicated as the tax code, but it's not far off. I like to, as an example, I like to say that if you are on a logging crew that has one number of employees, you are to be paid one way. But if you are in a logging crew that has a different number of employees, you're to be paid a different way.
Right.
So that's just an example of the weeds that one can get into in looking at this.
Yeah.
But in terms of this change that's important, generally employees are either what we call non-exempt or exempt, meaning they are exempt from the requirements to pay them time and a half overtime for hours worked over 40 in a work week, or they're non-exempt, meaning you do have to pay them time and a half their hourly rate if they work over 40 in a work week. So traditionally, the majority of the jobs that we see out in the state and otherwise are non-exempt jobs. So, for instance, an employee working at Walmart as a stocker would be non-exempt,
Right.
and so you would have to pay them time and a half. Or people who a waiters at a restaurant, they're definitely non-exempt. They have a different portion of the law that applies to them in terms of tips, but they would be non-exempt. You would have to pay them time and a half for any hours worked over 40.
Right.
Now, what we typically call salaried employees are exempt. And I'm saying this kind of with a little hesitation because that is one of the tricky things that employers get caught up is who can you pay a salary?
Right.
And, a salary traditionally is you pay them a set amount per week, and then that covers all the hours that they work in a work week, be it 30, be it 40, be it 50, be it whatever.
Right.
You're just paying them, just for example, saying $1,000 a week, and therefore not having to pay them time and a half.
Right.
But you can't do that with everybody.
Right.
It depends on multiple things, but primarily it depends upon the primary job duties of the employee and their job position.
Yep.
So, for instance, going back to the Walmart stocker example, Walmart could not just decide, hey, we want to start paying our stockers as exempt employees, as salaried, so we don't have to keep up with their hours. They wouldn't be able to do that because of the job duties of a stocker. The law wouldn't allow that.
But maybe a manager.
Right.
Could be.
And that is, but that requires kind of a careful analysis because that is exactly what you've described. Managers make up a lot of lawsuits in a lot of cases. So a classic example, I'm old enough to remember Blockbuster videos. My kids would have no idea what I was talking about. But there was a big case about Blockbuster videos, and if you'll remember, that's where you went in the store and you got the little video cassette box and took it to some guy at the counter, and he hands you the video and you rent it and take it home and everything like that. Well, they were calling the guy behind the counter. Blockbuster gave that guy a title, oftentimes, of assistant manager.
Okay.
So, and then paid him a salary.
Gotcha.
So some intrepid plaintiff's lawyer with great success sued Blockbuster and said, well, no, I know you're calling this guy an assistant manager, but his job duties are the same as the stocker in Walmart. All he does, he's not hiring and firing people, and he's not really exercising discretion. He's just handing out videos. And so you can't pay him a salary and avoid paying him overtime pay. That's kind of the classic example of what we call exemption cases or managerial exemption cases. So if you are an employer and you wish to employ somebody, pay somebody on a salaried basis, I would recommend, to be honest, that you talk to a lawyer about it. But an analysis needs to be done on the job duties that this person is either doing now or what they're doing now, and any changes what they're going to be doing in the future. Because the title is really meaningless. So
you could make up a title.
But one of the factors that the law and courts and the Department of Labor uses to determine as to whether these employees are exempt or non-exempt, meaning whether you have to pay them overtime pay or not, is their weekly pay. So even if somebody's job duties truly are managerial, if you're not paying them a weekly rate up to a set level, you have to pay them overtime.
Gotcha.
And so that is called a salary basis portion of the exemption. And so those are set by federal law. And bringing it all around back to your question, that is what is changing.
Right.
So right
July
now,
1st, right?
Right.
Yeah.
So July 1st, well, right now the limit is $684 a week, which is equivalent to $35,568 per year.
Right.
So, but really the weekly amount is what's most important.
Okay.
So, because, for instance, if you are going to pay somebody $35,000 a year or something, you can't just pay them above the $684 1 week and then less later and get by. They have to be, everything for the overtime law is done by the work week.
Okay.
So even in computing damages and in every aspect, it's done week by week by week.
Okay.
And so every week, if you are going to pay somebody on a salary, they have to be grossing. Now, this is gross, not net, but they have to be grossing it right now at least $684 per week.
Right.
And that is what is changing. The Department of Labor has upped that amount.
Right.
And so as of July 1st of this year, it's going to go up to $844 per week.
Okay.
So if you are right now paying somebody $684 per week, and in July you are continuing to pay them that amount on a salary basis, you will be violating the overtime laws.
Gotcha.
So
have you seen people proactively give people raises to avoid that?
Yes. Okay. I mean, they would almost have to.
Right.
Because, and what it really should encourage is not only a cost benefit analysis to look at that position and decide, it may be more prudent to just pay somebody hourly with overtime. It depends on how much they're working. So, but employers should be aware that if they have already done that analysis and they are paying somebody a salary less than $844 per week, then as of July 1st of this year, they are going to be in violation of the law and owe them some back overtime.
Right. And that's going up again in 25?
Correct.
Yeah.
It is scheduled to go up again in January of 2025 to stair step up to $1,128 per week, which is equivalent to roughly $58,000 a year.
Yeah.
Right. And the idea is
that's not a big gap there. 6 months. Yeah.
Right. It's it's a small amount of time to kind of do that analysis. And the idea is that because it's a trade-off, because these people are not getting overtime pay for the hours that they are working.
Right.
So the idea is that, if somebody is working 70 hours a week and they are only making $684 per week, the more hours they work, the lower effective hourly rate they make.
Correct.
And so the law or the Department of Labor has said that, that they should be paid more. Now, one thing that is important to remember in terms of the timing is that these changes are being made by the Department of Labor, which is an arm of the government.
Right.
So these are administrative changes.
Right.
So it's real law, but people and states can challenge it in court, which is what it's already happened.
Oh, really?
So it's out in Texas. It just got filed recently, and I forget who exactly has challenged it, whether it be the state of Texas or whether it be an employer in the state of Texas, but it has been challenged. So right now, these deadlines are still current, but what a court may do, very well could do, is they could stop it. They could enjoin it and say, until we make a determine whether or not this is constitutional, then we're not going to let you, Department of Labor, make this change. So
Okay.
right now it's on, and these deadlines are in place. But
If that case gets
there's a possibility the court that will either knock it down, or a court will say, until such time as we've determined whether this is constitutional,
Gotcha.
then it can't be put in place.
Gotcha.
So the bad news is, an employer's not going to know unless they're monitoring. So the good news for lawyers is the solution would be to call a lawyer. Although I would submit a lawyer would be, if you have multiple employees who are going to be affected by this, I don't want to say proposed change because it's a real life change right now, but
it's a law.
Right.
Yeah.
It's a law, not a law from the standpoint of the authority of the Department of Labor is a law.
They didn't pass it through Congress and all
exactly.
that.
And these have been challenged before, and really the administration can rescind it. So if there's a change in the administration in November, it may be, for instance, before even this January 1 change, it may go away. It may, well, it's not going to go up, but you know, it may go down. Who knows? Yeah. But so there's still, despite the fact that the Department of Labor has published these changes and dates, there's still a chance that they may not kick in. But a prudent employer right now should act as if they are going to.
And be getting prepared for that.
And be getting prepared for it. And the way to get prepared, again, I would say, is to do an analysis of the job duties of the position, and then just a cost-benefit of analysis to determine whether you would rather raise their salary pay to these amounts or whether you would rather start paying somebody, the same person, hourly and keeping up with their hours and pay them time and a half on an hourly rate.
If I have a restaurant and a general manager's working 80 hours a week, it's probably not going to be in my best interest to pay him the overtime.
Probably not. Although you would have to, you've hit on another source of common cases. You would have to do a realistic analysis of what that general manager's primary job duty is. Because what we have found that oftentimes, particularly for smaller businesses, is that if these salaried people are working 80 hours a week, they're not really doing administrative duties 80-hour weeks. They're covering for hourly employees who either don't show up or they're, there's just too much work. So if you've got a general manager who is spending 50 hours of his weeks cleaning tables and filling in cooking and doing things like that, if the courts determine that his primary duty really is not administrative, then you're going to owe him overtime for those 80 hours regardless of how
long he's worked.
So
can get costly.
It can get costly. So again, and I hate keep going back to it, but I think it's prudent to do. You just need to do an analysis legally of the job duties and the compensation that you wish to pay, and make an informed decision based on that. Right.
Okay, well, that's good stuff, because that's coming up. This Alabama for 2024 and half of 2025, with this, if you work overtime, you're not liable for state withholding for the overtime hours. Have you seen much on that?
No, because to be quite honest, as soon as I hear withholdings or taxes or anything of that nature, I say, call an accountant. But no, most of the legal cases are overwhelmingly about the actual overtime pay. So if I'm getting ready to hire somebody and I don't know if he's exempt or not, what's the best thing to do? Reach out to somebody like you, or is there a website? Go to the website. Is there a list of? Yeah, so you can go to the Department of Labor website. And they will have a wealth of information and direct you to the laws and statutes about it. The problem is it's almost too much of a wealth of information. So one can try to kind of do that analysis on their own, but whether it be me or anybody else, I would say maybe reach out to a lawyer, because the risk of doing it, the pain of doing it wrong is pretty significant.
Yeah.
So under the FLSA, the overtime law,
Right.
If someone is able to prove in court, say your restaurant manager, say he's an assistant manager, and he sues because he says, really, I'm bussing tables. My primary job. I can't hire. I can't fire. They call me an assistant manager, but I'm not doing anything different than I'm just a fill-in cook, table busser, everything like that. So say that as the employer has paid him a salary, and he contests that in court and says, no, I should have been paid hourly, and therefore I'm owed a bunch of overtime that I never got paid, and he goes to court. If he is successful, very likely, and say he's owed $10,000 in back overtime, very likely the court will assess that $10,000 plus another $10,000 as liquidated damages, because that's what the law calls for.
Okay.
Plus his attorney's fees.
Right.
So you may have saved $10,000 in overtime on the front end, but it's a risk that you may lose, $50,000 if he is successful in court. Now, of course, there's no guarantee that he will be successful in court, but
it's happened a lot, hasn't it?
Yes, it has, and it is again. So it's something to pay attention to in doing this, to really focus on realistically what the job duties are and the amount that you're paying him or her.
All right, that's good stuff. This EEO data collection, we get calls about this, and what exactly does that mean? What is that?
So it is, as you described, we talked before the show, it's almost like a census.
Right.
So the EEOC is requiring larger employers to provide them with some data of their employee, of their workforce, that includes their job titles, their ethnicity, gender. I think that is
that's pretty specific.
I guess that's it. Oh, and race. Race or ethnicity.
Right.
And the idea is, again, that it's almost like taking a census.
Right.
So I don't know this. I suspect that one of their goals in this is to try to determine if the work of the EEOC is helpful in broadening the workforce and more opportunities for everybody.
Gotcha.
So, but this is a way that they are attempting to track that.
Right.
And so if you're an employer and you have more, so it applies to private employers who have 100 employees or more.
So if I have less than 100 employees,
you don't have to worry about it.
Gotcha. Okay.
Right. So, and federal contractors, it's 50 or more.
Okay.
So if your business contracts with the federal government, it's 50 or more.
Gotcha.
And so you're required to fill out these forms. And there is, on the DOL website, the forms are there, and there's a pretty good explanation of how to do it on there. But if you don't do it, you will be subject to penalties. Now, a piece of good news is that this has been in place for a few years now, but not a long time. So it's just now coming out with any lawsuits that the EEOC who has filed to enforce this against companies who don't comply.
Okay.
And so through that, we can kind of see what the steps of the process are. Now, I'm encouraging everybody to do it, of course, but it's not like if you don't do it, they come in and take a bunch of money right away. So they will send you a notice of non-compliance if you don't do it.
Now, will they send me, say I reach 100 employees last year, am I required to know that I'm supposed to go do that, or will they send me something saying you're required to fill this out?
You're required to know.
Okay.
Just like, for instance, an example is Title VII requirements. So the legal requirements regarding gender discrimination, for instance, those apply to private employers that have 15 or more employees, and not 15 or not 14 and under. So you would not, if you had 13 employees and you added 5, the government wouldn't notify you that now you're subject to Title VII. Similarly, no, they're not gonna notify you that, hey, now you're subject to these EEO recording forms that you have to send in, reporting requirements. But they will give you a chance, because it's a relatively new program, in that they will send you a notice of noncompliance, and there's no financial penalty with that. So if you don't do it,
you get a notice.
And I'm not recommending that people don't do it and then just wait for the form. But if you don't do it, you will get a notice of noncompliance. And based on a couple suits that they recently filed, they even reached out a second time. So there was a pretty good bit of work on the EOC to try to notify you, because really they want the information. I mean, they in fact, the lawsuits that they have filed so far have only asked the court to compel you to give them the information. So they're not really asking, as of yet, they can, but they're not asking for any monetary penalties. They just want you to do it. But it is there's a pretty good explanation on the DOL website of how to do it. But it's also important, it becomes part of the EOC record, of course, on your company. So, it's important to do it accurately. Because, say that later there is a discrimination case against your employer or some other type of employment case.
It's on the record.
So it would, be evidence of how many, because you're going to have to attest to it, of how many employees you have, and again, what race and gender and things like that. So, so that's another incentive to make sure that you do it accurately. And they're just asking for a snapshot in time. It's not, you don't have to average,
is it a yearly thing, a one-time thing?
I believe that's a good question, and I don't know the answer to that, whether it's yearly or quarterly.
So at least annually, though.
It's at least annually, yes. But they are, again, it's what's important, kind of with all the employment laws, they're kind of weekly snapshot laws. So what's important is that particular snapshot in time.
Right. So if I have a company with 100 employees or more, I've probably got an HR department that would be able to handle all this stuff. They should be able to go to the DOL website and figure it out. Much more so than, say, an analysis of somebody's job duties. I would say that somebody could give that a pretty good shot of handling it on their own. You wouldn't. You're certainly welcome to get legal help with it, but if you're a company that has 100 employees, you probably got some HR people, and they all would be able to, should be able to handle that. All right. So I guess one thing we've talked about is, and we were just talking about it out there, is maybe an employer doesn't have a handbook or policy, and when a lawsuit is filed, you have nothing to go back and look at. How important is it, even if it's just basic, for somebody to have an employee handbook?
Yeah, that's an excellent question. And the answer is, it is important to have one, and it's important to pay attention what's in it based on your business's needs. And so the reason I say that is, there are certain things that, if they are in a handbook, that will help not necessarily insulate an employer from lawsuits, certain types of lawsuits, but will certainly help them defend it. And they're good for the employees too, because the employees are proactively providing them with information they need. An example, of course, example, of course, is an employer that has a sexual harassment policy or an anti-discrimination policy. it would be very wise to have a handbook that gets to every employee, that spells out for them clearly what to do if they are harassed, or what to do if they do feel like that they are being discriminated against. What to do if the person who you believe is harassing you or discriminating against you is your manager, and therefore you're scared of retaliation. How do you go over his or her head? How do you do that? And so
all that would be spelled out in the handbook.
All that would be spelled out in the handbook. And so it's good for the company to have, because it provides a good process to try to eliminate those types of problems. It also helps them legally. So if they do get sued, or they do get an EEOC charge alleging that an employee has been discriminated against or has been harassed, the existence of that policy in a handbook is a defense. So they can tell a court, hey, this person, for instance, didn't report it on the 1-800 number that was in the handbook that we gave them. And so, that's not a surefire, it's not going to make it totally go away.
It's just more evidence in your defense.
It would be a helpful defense. But importantly, from a business perspective, you want your employees to have recourse, and you want people to have a system that they can trust, that allows them to report those types of things. As an employer, you want to know. You want to know if you're having that problem. I would say, speaking more generally to the employee handbook, depending on the size of your employer, though, of your company, you want to be careful to have not too much in the handbook. So if you are a giant employer and has, thousands of employees, it probably makes sense, or it may make sense, to have a point system or something like that in place that you put in a handbook for discipline. Right. So if you're late, you get a point. If you're late twice, you get 3 points. Or something of that nature. And that's just purely a business decision. However, if you're a smaller employer,
10 employees,
something like that, it may not make sense to have a system like that in writing, because then that will hurt some of your flexibility. Because if you put it in a handbook, then you've got to comply to it to the letter with everybody at all times. So, and it doesn't quite give you, if you're a small employer, it may not give the flexibility that you would like to deal with employees differently. Because there may be long-time really good employees that screw up one time, as opposed to somebody who's only been there 2 days and screws up the same way. You want to be able to treat them differently. But if you've got rock solid things in writing, you've got to treat them the same. So
because
again,
they can sue and say, look, it's in the handbook.
Exactly. That XYZ Corporation did not. They treated me differently under the handbook than somebody else. And so, again, it all goes back to kind of an analysis of what your needs are, risk-benefit analysis. If it makes sense to have, if you need, as a business, to cohesively run, to have a detailed discipline system, for example, then fine, put it in the handbook so everybody knows what it is, and you can rely on it. But if you've got 20 employees and you want to have a little bit more flexibility, I would suggest you still need the handbook, because you need the sexual harassment and anti-discrimination policies in there. That would be prudent for any employers.
Although it may not be required by law to have a handbook.
Correct. It's not. It's absolutely not. But it would be prudent. If I was advising any employer of any size at all, I would say that you should have an anti-discrimination harassment policy in writing. You don't necessarily have to call it a handbook. I mean, but that's available to everybody. Again, with the twofold purpose: most importantly, so that you can do the best you can to make sure that your company does not have harassment or discrimination, and it gives your employees a functional avenue of recourse within the system if they feel like that they're having that problem.
Right.
But it also will provide a legal defense. But that same employee may not necessarily need a detailed IT policy in their PAM book because it really functionally is not going to give you much, but it may create some liability down the road that you didn't anticipate.
Right. So what are you seeing? I know there's a lot of discrimination suits out there. What is there anything coming, any laws coming that you know of that we need to be aware about?
But you would be, or one might be surprised, is that there is not as many discrimination cases as one hears about. I mean, there are, and there certainly are elements of there certainly is discrimination out there. But the road for a plaintiff or an employee to successfully bring a discrimination case, contrary to kind of myth, is difficult. You have to prove it. You have to prove it, and you have to. I would submit that you have to go through some hurdles that you necessarily shouldn't have to go through. That one wouldn't have to go through if they had a car wreck or if they had something like that. But it is an important thing for employers to be mindful of. And also, I've seen that employers, which is a very positive thing, are paying more attention to it. They're being proactive about trying to enforce those policies, which is good. So there's certainly there are suits like that out there, but I know just being in the community, I tend to hear that like, oh, there's a million discrimination, and there's really not. There probably could stand to be a few more. To be totally honest. But the overtime laws, those you would be surprised, or one might be surprised how often that comes up. Because the other thing is, so the Department of Labor can bring their own overtime enforcement actions against private employers as well. So if you're an employer, not only is there a possibility that one of your employees may sue you and say, I am entitled to overtime, but the Department of Labor may show up and say, one of the employees has called us, or a former employee has called us, and we want to do an investigation of these pay practices.
Can the state do that as well, the state labor department?
Well, yes, the Alabama Department of Labor is, for better, they function along with the United States Department of Labor. So yes, the State Department of Labor can do that in conjunction with the U.S. Department of Labor because it would be under that federal law.
So we see way more audits for the state unemployment than we ever do with federal or anything like that.
Now, and again, just remember the distinction between unemployment and overtime. So, the overtime laws, again, are a federal law, but the unemployment laws, there is a state unemployment law and appeals process and so forth.
And we've seen a good bit of that recently. We get that a lot.
That is something, especially during COVID, and they really haven't caught up. When I say they, being the state unemployment people, because they just got a deluge. Of
overwhelmed.
They God bless them.
And they raised the rate and then brought it back down.
And then they just were overwhelmed. And so. It is, and that was problematic for both employers and employees. It is
But they're just now catching up.
Right. Yeah. I don't want to use the word mess, but it was not far from it.
Right.
It was tough sledding. And I admire those
remember.
people who were working down there because they were dealing with an impossible situation.
Man.
But
With no real warning that it was coming.
right,
Yeah.
exactly.
Yeah.
But it created problems for everybody. Plus, there was kind of a square peg and a round hole in that, in addition to the traditional unemployment, there was this, all the COVID unemployment, which was a different animal.
Right.
But then the same people were trying to deal with it, and then there was, again, on top of the higher volume of traditional unemployment.
Right,
So it was, and there still is. There's still a lot more than it was. We're having more people call in about unemployment than we were 10 years ago.
Okay.
Still.
Yeah. Do y'all help them through the process of?
Well, I don't know a whole lot of lawyers that actually we will represent an employer with unemployment, but there's. And we will try to direct employees that call in to the right resources online and things like that. But we don't really, it is rare that you will find a lawyer that represents an employee who is attempting to get unemployment. Right, yeah.
The process isn't that hard for them, I don't think.
It's not difficult.
Yeah.
What is difficult is the wait.
So,
and same thing for the employer.
Sure.
I mean, they want to end a matter, and it is difficult for them to end a matter because of the wait. But it's better than it was a couple years ago.
Yeah. So here's a question I just thought of: if my hours have been cut, can I still file an unemployment claim, and will they honor that? The state? Do you know?
You mean if you were working
full time and now I'm part time?
And now I'm part time.
Yeah.
Yes and no.
Okay.
That's not there's some factors that play into that, but those are also on the unemployment website. It would depend on how long you had been working at the company and, to what extent that they have been cut. Does your income fall now below weekly income below a certain level?
Gotcha.
If you are making $30 an hour and you get cut 10 hours, that situation is going to be treated differently than somebody making minimum wage that goes from 40 hours to 5 hours. So,
right.
But
it depends on the case.
It depends on the situation. Yeah. But and there also is what people, I don't know, they may be unhappy that I say this on this, but there's an unemployment office on Skyland Boulevard.
Okay.
So I have told people in the past, if they can't get through on the phone or if they can't figure it out online
they can go down there.
They can go down there and get some assistance. The people down there are nice and knowledgeable. But again, I don't want to then to blame me if 300 people show up tomorrow. But but it's good to know that there is a physical office here in town, and there may be more than one. I just know there's one on Skyline.
Right. Okay. Cool. All right. So the last thing I wanted to touch on was Alabama being a right-to-work state, and people ask me about that, and again I refer. But what does that mean?
Okay, it basically means Alabama's an at-will employment state.
Okay.
And that is a concept that is it's not a difficult concept, but it can be very difficult for employees to swallow at times.
Okay.
So, unless an employee has an employment contract. Now, this is generally, there may be some for, state employees and federal employees a little bit, but for private employers generally of any size, your employees are typically at-will employees unless that you have affirmatively made them a non-at-will employee by executing an employment contract with them, which is pretty rare.
Right, yeah.
So what that means is that you can terminate the employee for any reason that is not legally impermissible in terms of discriminatory, basically, or retaliatory. So, for instance, going back to our overtime discussion, if John Doe employee comes to you and says, hey, I think my job duties are such that I should have been getting overtime, you can't fire him for that. But if you need to downsize or you're just not happy with John's performance or whatever, you don't like him. He wore a shirt that you didn't like. You can, as long as it's not discriminatory, you can terminate him. And now the trade-off is, of course, that everybody's a little bit more comfortable with. Employees can quit at any time.
Right.
So,
I don't have to give you a 2-week notice.
Right. Yeah. Now, obviously, just in terms of general good conduct, I would recommend that people do.
But there's no law.
Right. There's no law that says that an employer has to give somebody 2 weeks severance.
Yep.
There's no law that says that an employee has to give 2 weeks notice.
Okay.
At-will employees can be terminated at any time as long as the reason is not discriminatory or retaliatory, basically.
Okay.
And so that's, again, at times difficult for employees, understandably, but I try to remind them of the trade-off that they could leave at any time if they would like.
Okay, awesome. Well, David, thank you so much for coming. If anybody has any questions, can they reach out to you?
They can, and I'm certainly glad to be here. I appreciate it.
Yeah.
If anybody, we represent employees and employers, so if anybody would like to try to do an analysis of some of the things we talked about, whether in relation to these higher amounts that they're going to have to pay salaried employees or not. Yes, our firm is Hardin and Hughes, and we have a website, and they can contact me through the website, or my number is 205-523-0463.
Okay.
They can contact me that way.
All right. Well, I appreciate it. Don't forget to like and subscribe to the JMF Advisor Show YouTube channel.
If you would like us to help your business or would like to suggest additional podcast topics, simply send an email to info@jmf.com.
And don't forget to subscribe to our podcast on YouTube and your favorite audio podcast apps.